docket. That is case number 107477, State of Kansas v. Joaquin A. Deanda.
May it please the court. Counsel, my name is Corey Call, representing Mr. Deanda. I would request 4 minutes for rebuttal, please.
4 minutes is granted.
Thank you very much. Mr. Deanda was convicted, he pled guilty to first-degree murder, premeditated murder, and the state sought a hard 50 sentence. At the hearing, the judge found one aggravating factor, that the crime was committed in an especially atrocious, heinous, or cruel manner, particularly that the desecration of the victim's body in a manner indicating a particular depravity of mind, either during or following the killing. The judge also found two mitigating factors, that the defendant was 17 when they occurred, and that it was committed while he was under mental or emotional disturbance, and found that the hard 50 applied. We raised 3 issues related to the hard 50, and then 1 related to a quirky post-release parole issue. The briefs and the trial obviously all occurred before Alene versus United States came down. So the landscape has changed dramatically. Under Alene, the U.S. Supreme Court...
You said you're raising 3 issues: sufficiency, Alene, and what's the third one?
The third one was that there was an autopsy that was admitted, but the coroner who performed who wrote the autopsy report was not present, and therefore the autopsy was hearsay. And then the fourth one was a post-release parole. So under Alene, this court's heard several arguments on Alene, and that the creation of a mandatory minimum essentially created a new crime, and I guess you'd call it an aggravated first-degree murder, and that accordingly a jury needs to find the aggravating element beyond a reasonable doubt. Obviously that wasn't done here, and the remedy is that because the crime did not exist, the aggravated crime did not exist when Mr. Deanda committed these acts, this court should remand it back, and he should be sentenced to a hard 25.
It's pretty critical with regard to sufficiency of the evidence, isn't it? Because the new special session, hard 50, excludes insufficiency of the evidence. It says if it's overturned for anything except sufficiency of the evidence, then you can have the new procedure on remand.
Yeah, I think that's and we can certainly talk about the sufficiency here. And
well, you raised that, didn't you?
Yeah. Sorry, that was the first issue. The district court. I guess I would also argue that I think there's some retroactivity. I don't believe the new statute can be applied retroactively, even if this court finds that there was sufficient evidence. But on the sufficiency, the judge.
Before you list what was or was not in evidence on sufficiency, I just want to ask a question. You of course, you're making the constitutionality argument. Here, didn't the judge say specifically that the heinous, atrocious, cruel aggravator was found beyond a reasonable doubt, rather than the usual?
The judge did.
Okay. That's a quirk in this case.
It is odd. I'm not sure it matters, because the judge acknowledged prior to they went through prior to the arguments and the decision, he said that Apprendi doesn't apply here, and that the facts must be found by a preponderance. And so he stated that they were found beyond a reasonable doubt, but I would say that that's sort of surplusage. The standard he was using, the legal standard he was applying, was preponderance. He just said that they were found beyond a reasonable doubt.
Okay.
And so I don't know that would save it, certainly from any kind of harmlessness.
When you say there really was only that one aggravator.
Oh, yeah, of course, yes, that's
Okay.
right. You're absolutely
All
right. Yeah,
right.
just
Okay.
the one aggravator.
Thank you.
The state alleged another, I think, but the judge found that it did not exist.
Okay.
And
I interrupted you. Thank you.
I guess it could be they, in the sense that the judge, the written findings of the judge on the one aggravator are I think, a little vague, because there were three findings there. One, there was contusions on the vagina, which would indicate intercourse. The judge said it was unclear from the record whether that intercourse happened prior to or after death, and although it was likely that it happened after death. Also, that actions were taken to ensure that she was dead, and that that Mr. DeAnda heaved her into the trash without the slightest deference to her person or the person she had been. Those were the three things that he listed the state had proven. As to the last two, actions to ensure that she was dead, I don't think shows there weren't extreme desecration of the body. There were some cuts, and he stood on her neck. But that seems to me to be part and parcel of the depravity of killing someone, is that you want them to be dead. And he didn't go to extreme measures to desecrate the body. He said, check that she was dead. So I don't think that measures up. And as far as heaving her into the trash, disposing of the body, in State v. Buehler-May, this court talked about that concealing the body is frequently part of the scheme of killing someone. You want to conceal. And again, there doesn't seem to be anything extreme here. The real, I think the factor to talk about is the intercourse with her, around the time that she was dead, and certainly that is something that is outside the social mores. If again, there's still a question of whether or not she was dead. The coroner at the preliminary hearing, the person who did the autopsy report, testified that there were contusions on the vagina, which would occur when the heart was beating, therefore she was alive. And of course, at that point, Mr. DeAnda was charged with rape, and which was later dropped as part of the plea agreement. And then when we get to the Part 50 hearing, then the question is whether she was dead or not. And the difference about this case, about if we assume that the judge accept the findings that he had sex with her while he was dead, which, by the way, comes from his testimony. He was involved at a learned interview. He stated that she was dead, and he had intercourse with her. And the purpose of that wasn't any sort of desecration. It was, he believed that he would achieve some sort of enlightenment by committing this act. And it wasn't the particular depravity of the desecration of the body. It was to achieve his own enlightenment, which is unquestionably delusional. And again, we're outside the social norms, but it doesn't reach the level. And the way the brief puts it, I think as well, is that he didn't have the intent to desecrate the body. This wasn't an act in which he was attempting to demean the body or desecrate it or remove the sanctity of the body. It was to achieve his own enlightenment. And so that and in Buehler-May, this court talked about as far as desecration of the body, that there can be, that it's less, or it's not just the act that's occurring, it's also the intent of the actor. You think of burning a body. Could be desecration, could not be desecration. Again, hiding a body, secreting the body away, could be desecration, could not be desecration. And it depends on the intent of the actor. What did they intend? And I think the unquestioned testimony here, uncontroverted testimony, is that Mr. DeAnda's actions were to achieve what he felt would be some sort of enlightenment. And I think Dr. Logan, an expert for the defense, testified that Mr. DeAnda wouldn't even believe that this was morally wrong to have sex. He believed that it was morally wrong to kill her, but as far as the aggravating factor of having sex with her, he wouldn't even believe that was morally wrong.
Couldn't his testimony, or not his testimony, but his statement to the physician, as well as, what we know about what his intent was about enlightenment, been so incredible that it wasn't believable as to intent?
I guess. I mean, the fourth part of the problem is that the only evidence that he had post-mortem intercourse with her comes from his testimony.
Well, Well, the autopsy was inconclusive.
That's right, the autopsy is inclusive, and the coroner testified
There's
that...
no, there wasn't, it wasn't inconclusive as far as rape, but inconclusive as far as whether it was post-mortem.
That's right, although I think the defense expert testified that because of the delay in performing the autopsy, that the bruising could have just been, I'm probably using the term lividity wrong, but could have been body settling, and there may not have been any actual, there may not have been contusions at all. It may have just been part of the body. And so I guess I suppose that at some point anytime you're dealing with someone with this kind of delusional behavior, you could say, well, it's unbelievable because no rational person would believe that. No rational person would think that they could achieve enlightenment in this way. But we're not dealing with that here, and certainly there was no experts from the state to contradict that, but it was his testimony. But I suppose that the judge could have found that there were no findings that he found the defendant's version to be so unbelievable, or that he discounted the enlightenment.
I guess maybe the way I should phrase it is, I mean, I guess it's not so much intent. I thought, like in Bueller May, that we were talking more about we didn't really say intent. We said it has to show a certain depravity of mind. And regardless of what he might have said, doesn't that show a depravity of mind?
I don't think so, because I think, again, you have to look at part of the depravity of mind is the reason why the act was committed. It's not just the act itself. The depravity of mind, if he believed this was for a noble purpose, then that doesn't show a depravity of mind. It may show a delusional mind.
So every time,
yeah.
so every time a delusional act by a perpetrator commits an atrocious crime, we view it in the state of mind of the actor, and therefore, if it's delusional, if it's rational in his or hers mind, achieving nirvana, that diminishes the cruel and atrocious manner in which the killing was perpetrated.
Well,
how can that be? I mean,
because
how would we ever have that
No,
factor
I
come
think
into
you
play?
have desecration of the body. I think is a good example. You have where the intent is to despoil the body, and I think the legislature put in there the language "particular depravity of mind," and I believe the purpose of these, of the hard 50, is to punish the depraved mind, not necessarily the depraved act. It's worse because this is a person that believed they were committing an act. They understood that they were committing.
Partly to punish, it's partly to protect. It's to protect the people.
That's true, certainly. And he's getting a life sentence. And it's a question of whether it's hard 25 or hard 50. And I think it's partly to protect, but I think the gravamen, especially where they use the language, a particular depravity of mind, they're asking this court to look into the mind of the defendant. It's in the statutory language.
I see counsel's out of time. Do we have any further questions? Do you need about 30 seconds to wrap up, or do you want to wait till rebuttal?
I can wait till rebuttal. Thank you very much, Your
All
Honor.
right, thank you.
May it please the court. Linda J. Lovemeyer, appearing on behalf of the state of Kansas. As Mr. Call stated at the beginning of his argument, this was briefed and the sentencing occurred prior to the Supreme Court's ruling in Aileen. So we have not briefed those issues, but I know that the court is well aware of the background and what the arguments that other counties have been making regarding the constitutionality under Aileen of the hard 50. We are asking, first off, that the court, in fact, find that the hard 50 prior to its recent changes, that it was in fact constitutional at the time of our sentencing. That's based upon the fact that this was the sentence prior to the hard 50 finding was going to be life regardless, and so it's an indeterminate sentence and all of those arguments. Additionally, we would also ask that because it can be applied constitutionally, that the court consider in this case that it was in fact applied constitutionally and therefore can be upheld. Finally, if the court deems that the Hard 50 scheme prior to the amendments or the changes is in fact unconstitutional, we are asking for remand, and we are asking that we be allowed to resentence pursuant to the changes to the statute that allow for the presentation of the evidence on the Hard 50 to a jury.
Did the jury find that the crime was committed in an especially heinous, atrocious, or cruel manner?
There was no jury.
Without that jury finding, what was the longest minimum term that the judge could impose without making additional findings?
Our argument is that the longest minimum term is life.
Right.
The parole is a post-sentencing relief outside of the scheme of the sentence. That is what we would be arguing with regard to that.
In other words, you're saying the lien doesn't apply to any case that was decided prior to a lien?
That's our first argument with regard to it, yes.
How do you get around all of our case law that says if it's pending on appeal, then you apply that decision? Wasn't this case pending on appeal?
It was pending on appeal, yes.
Assuming that it does apply, then how do you get around the Apprendi and its progeny that says that you can only sentence based on the facts that the jury found? And of course, before a lien, that was only on the maximum, but a lien says that applies to the minimum also. So applying that concept that the only permissible sentence was what was permitted by the facts actually found by the jury, how can you say that the Hard 50 minimum was constitutional?
Under the facts in this particular instance, the defendant, first of all, he waived his jury trial through his guilty plea and agreed to allow us to do sentencing. I mean, that was on the table. Everyone knew the state was going to seek the Hard 50 at the time of the plea, and that we would be presenting evidence to the court. And I understand what you're saying, that a jury didn't in fact find this, but based on the plea agreement, in fact.
So you're saying he waived his right to have a jury determine those facts by pleading? Don't we have cases that say that you have to make a knowing waiver and have to advise that he has a right to have a jury? And obviously that wasn't done because it wasn't the right at the time.
Right, and I concede what you're saying on this. I mean, our basic argument is that there is no floor and no ceiling with regard to a life sentence. That's our first stepping off point for the application in this particular situation.
So does that mean we can just vacate the Hard 50 part and go on? And just it would just impose a life sentence?
No, because then the question then becomes whether or not the Hard 25, I mean, I'm assuming if you vacate the Hard 50, you're going to be saying that the Hard 25 applies?
That would be under the facts that were pled.
Right, under the facts that were pled. And I understand what you're saying, but we are asking that if the court finds it to be unconstitutional, that we be allowed to present the evidence. This plea agreement.
I wouldn't be doing that. If I accept your argument,
okay,
that somehow Hard 50s are just when you're eligible for parole or probation, then why can't we just vacate the Hard 50 part? And that would get you back. I mean, we're not finding anything unconstitutional. We're just I guess we're just vacating that piece of it. Based on your argument that it really doesn't matter.
Well, obviously it does matter, or we wouldn't be asking for what we're asking for. And I understand what you're saying about that, but we would ask for that to be the remedy should the court find.
Let me ask you this. We've been dealing in these cases with whether there's a harmlessness test that can be applied to this. And you didn't really say anything about that. You asked for remand. Would you agree in this case that when your mitigators involve mental condition of the defendant as well as age, that there's no way a court could play a harmless error analysis, and so it would really have to go back?
I was going to bring that up. Yes, thank you. There would be a good harmlessness error or a good harmlessness argument in this particular instance because it's clearly what happened in addition to the defendant having sexual intercourse with the victim after he believed her to be dead for the purpose of enlightenment. There was evidence of postmortem burn marks. There was evidence of postmortem cuts to her body. There's a lot of evidence regarding the depravity of mind and the desecration of the body, as was discussed.
But on the mitigator side, so you're talking aggravator. On the mitigator side, the defendant says I shouldn't be sentenced to hard 50 because of my mental condition at the time. I mean, when a court is trying to apply harmless error kind of test, I don't see how we can look past that mitigator and say that the error was harmless when part of the excuse or the ability to argue against the hard 50 is this controverted mental condition issue, that there seems to be a reasonable basis for the defendant arguing.
And yes. However, in this particular instance, that mitigator was one that was only found by a preponderance of the evidence. Certainly the judge made the statement that that was not found beyond a reasonable doubt, whereas the age, the desecration of the body, the depravity was in fact found beyond a reasonable doubt. So if you looked at it from that standpoint, the judge found, although he wasn't required to find a quantitative sort of analysis there, he did make a quantitative statement about the weight of what was placed before him.
But the question, I think, is why would we decide here on our own that if this had gone to a jury as required by the Constitution, that the jury would have found the same way the judge did? I think that's the question. And in the past, like on the Reyna cases, you're either 18 or you're not.
Right.
And uncontroverted evidence that the defendant was over 18. Here, as Justice Biles is saying, you have a weighing
Right.
that's going on, and how can we have that level of assurance that we need to be a super jury and do the fact-finding here instead of letting a jury do it? How can we ever get to the point where we can declare that the jury would have weighed a certain way? I think that's really the bottom line of what we're trying to get you to explain to us.
Particularly when the mitigator is mental condition. It's different. I mean, there are objective things like age. And Rena, we said, here's an age. Yeah, there's a bunch of evidence. It's there. Here we've got a mental condition.
Right. I don't know that I have a sufficient answer to what you're asking. And I think I'm operating perhaps at a bit of a disadvantage, having not fully briefed these issues. And should the court choose to allow us to go ahead and make supplemental briefings, that may be something I could explore a little bit better. But as of today, I don't know that I could give you a real sufficient answer, so I'm not going to attempt to do so.
Do you have any further presentation, counsel?
If there are no other questions, I will yield. Thank you.
Any further questions? All right, thank you. Any questions for counsel before he waives? All right, thank you. Thank you both for your arguments this morning. Court will take this matter under advisement.